We are now officially being recorded, but with notification. Hello, Brenda. How's the weather out there?
It is amazing, very spring-like.
Wonderful. It's about time, right?
Yes. How about out there?
We actually have a beautiful day. It was made a little bit less beautiful by my having to spend $900 for plumbing today. But,
ouch.
But you know, at least the plumbing is working again, and I found out some good things about the condition of things outside of the house. So I know that we're in pretty good shape now that everything is back in order. So I guess you pay for the peace of mind, right?
I guess. Wow.
And since we're being recorded now, I have to decide how much I'm going to tell my wife the plumbing fix cost. I have to decide if I'm going to discount it for the family. Oh, it was 200
That's
bucks.
better.
It was easy.
That's on a need-to-know basis.
Yeah, right.
Hello, everybody.
Hello.
Hi, Norma.
How are you, Terry, Charles, Lori, Scott, Jay, Brenda, whoever I see. Did you get your second shot, Terry?
Oh, yes. Oh,
Great.
it's long past.
Yeah,
Thank goodness.
us too.
However, the NBC News the other night that had this young woman who for some reason had both shots. And it was long past her shots. And she got COVID pretty severely, not enough to be in the hospital, but she was very sick. And it was like, oh boy, kind of put a damper on things.
I don't know if I believe it.
Yeah.
Well, they say that, it's been reported that there are breakthrough cases. That's why it's 95%, right? Not 100.
99.
There was a young woman in Northbrook who was vaccinated and got very sick. Her kids got sick and then she got it. So that's 5%, I guess.
Hello, Herb.
Did she stay out of the hospital though?
Yeah, she was only sick for a couple of days, but really sick in bed.
Okay.
And she tested positive for it as well. So it's one of those fluky things. It's been on the news all weekend. She's been on NBC News.
How long were these people supposedly post-vaccinated?
She had been 2 weeks, more than 2 weeks. She thought she was in the clear, and then her kids came home from school. They were young children, about 5 and 7, and they got it. And then she came down with it. It happened. It's going to happen, but
Well, it's kind of like
pretty rare.
the conversation I had with Amy Goralnik, where she said, we may all be vaccinated and we may still be using masks in appropriate places just to be safer.
You have to use masks.
Yeah.
Otherwise, you can spread it to other people because you can still pick up the germ and pass it on, even if you don't get.
Right. And plus, we don't know about the variants yet. But I keep hearing Dr. Fauci say the vaccine keeps you out of the hospital, off a respirator, and you don't die. That's the big part.
I'm going to hold them to that in case they do.
All right.
You listen to Scott Gottlieb every Sunday morning. He's
Yeah, but he's more positive than Fauci. I listened to him this morning. I
didn't think he was positive at all.
I did. Martha Brennan kept trying to get him to be more negative, and she kept wanting him to say there's a fourth one, and he kept saying no, it's not.
I didn't hear that.
Hey, did you hear about the two atoms that were racing one another, and one of the atoms lost an electron and said, gosh, I think I lost an electron, and the other atom said, are you positive?
Very good, Larry.
I think we're going to operate on Jewish Standard Time, and we'll give a few more minutes for a few more people to arrive.
Okay.
I guess he just came to give that joke and then leave.
Yeah. Who here is double vaccinated?
Hello, Lori.
Is it a minion? Can we do services on Friday?
No.
Not
No,
yet.
not in this group.
You're in, I thought you went to Arizona.
I am.
Okay, so then what are you sending us to the temple? You're not gonna be there.
Well, wait till I get back after Pesach.
Fine, that's
For
fine.
people who are not double vaccinated, it is still safe to come to services. We do still maintain proper protocols. So even if you're not vaccinated or not double vaccinated, it's still safe to come to services. Please register so we'll know, so we do set up separated seats.
Hey, Jay, it was great.
We only
not
have
ready
it on
to come back
Saturday.
for
We don't have it on
Everybody's
Friday yet.
thinking once.
No. It's
Jay,
only-
it was great to see your cooking lessons on YouTube.
Oh, yeah.
Thank you. And give me likes,
yeah.
give me likes.
I did, and I shared them. I shared one of them on Facebook. I'm going to mention it while you're here, Jay. I really like the fact, and we don't publicize it, that the services are on YouTube as well.
Yes.
Yeah.
Because I can get them on the big screen television down here.
Yeah.
And I'm not distracted time to see what everybody's doing, and I just stay focused on it. And yeah, it's Len. And
We like to keep our audiences riveted.
but we need to tell people that it's there.
They know.
We don't advertise it in the bulletin. We don't advertise it in the.
No, that's a good point. We'll look at that because, it's not just Zoom, it's also on YouTube.
That's what I'm saying. I'm watching it on YouTube, and I actually share it back to Twitter, and I share it to Facebook as well.
Sheila, you're muted.
Sheila's muted, yeah.
And I sent the link to yesterday's parents to my mind went blank.
Oh, the Slades.
I sent the link to the YouTube to the Slades saying, because last time a year ago, I did screenshots of the first bat mitzvah. So, and snuck them to her, but today, I said, now you got the whole thing, you can keep it. So
I
that's
sent
great.
I sent your food demos to Leah.
Oh, thank you.
But,
Thought
it
you'd
just
appreciate
happened.
it since you were her sous chef that day.
Appreciate it.
I subscribed to the West Suburban YouTube site, so I got them, they just popped up when I opened my browser.
We're getting it.
Carol, I signed up for several of her cooking classes.
If
Going tonight?
It's at 9:30 is the only problem.
Oh, yeah, it's late. Because it's in
But,
it's in San
Monday,
Diego.
I think.
all
There's a
right,
couple others. There's an Italiano one.
Ladies and gentlemen, I think we are going to begin. So if you wouldn't mind muting yourself, I will introduce our speaker for Temple Talks number 3, and also give you a few pointers about the format. So first of all, we are very, very excited to welcome Scott Frankel, who together with Lori Myers and long time members, and we miss them very much. So it's really nice to be able to get them back on the screen and see them and be able to chat with them. I know some people have been able to go visit you guys down in your neck of the woods, but most of us have not had that pleasure.
Everybody's invited.
Okay, thank you. So Scott Frankel is currently a federal public defender in the Northern District of Indiana, based in South Bend. Scott represents indigent clients charged with federal crimes. From 1992 to 2018, Scott was a partner in the law firm Frankel and Cohen. Scott primarily defended serious state and federal felony cases, including white-collar fraud, blue-collar fraud, drug cases, and violent offenses, including murder. Scott has successfully represented individuals in capital murder cases, including one matter in which the client was acquitted by a jury of all charges. In 2018, Scott ran for local judge and lost, and he says he does not plan to put himself through that again. And I would be remiss if I didn't mention my awe at his skills at Ultimate Frisbee up at the Kala, and hoping that we can all be together again at some point soon in the future. And without further ado, Scott Frankel.
Thanks, Charles. And I want to thank the Temple for inviting me to give this presentation. It's an honor to be asked to talk about myself and my career and my experience with criminal defense. I thought of my presentation as sort of a hybrid. I'm going to talk about my experiences as a lawyer, since I've had a lot of different opportunities during my career, and also talk about the law itself and some of the, give you some recollections of stories that I've had along the way. Okay, so I'm going to cover a lot of ground, and I think there's also going to be time at the end for questions. So we can see the first slide.
Okay, here we go.
Okay. I love this quote from Clarence Darrow, who is the patron saint of criminal lawyers. Criminal lawyers are generally viewed suspiciously, not only by society, but also by other lawyers, meaning lawyers who represent corporations or white collar interests. To me, a real criminal lawyer is not only happiest in the courtroom, which is where Clarence Darrow was happiest, but also someone willing to represent anyone, even clients who are unpopular or reviled. And I've had my share of reviled clients. So I have represented doctors, bankers, lawyers, had a lot of white collar type clients, and I've represented them with great success in state court and federal court. I've also represented murderers, gangbangers, drug dealers, and sex offenders. And the mission for a criminal defense attorney is always exactly the same. Do your best and try to win the case. I'm always trying to win the case. It doesn't matter who the client is or what the charges are. So I guess the first question to answer is, how did I get here? The first step was deciding to go to law school. And you could put that first slide up there. I really had no plan on becoming a lawyer. I was really lost after college. It was 1981. The economy wasn't that great. And I was looking at showing my parents pamphlets on welding school, believe it or not. But I had a bunch of friends, you know, my peers from high school. They were all applying to law schools and getting into Ohio State Law School. So for want of anything else to do, I really didn't have any direction. I applied to law school and got in. And I did okay there. I graduated with honors, and I ended up editor of the Law Review, which opened up opportunities for me. So you can put on the next slide. And the first thing I did out of law school is I clerked for a federal judge in the Southern District of Ohio. His name was Judge Porter. He had already been on the bench for decades. He had been a state court judge and a federal judge. He was a very thoughtful man, and he had presided over the desegregation of the Cincinnati Fire Department and the overcrowding of the jail. So he was something of a civil rights icon in Cincinnati, which some of you may know is a fairly conservative town. Now, most of the work we did was completely non-ideological, and judges take an oath not to be partisan. So it came as a funny surprise when one time we were having status hearings in the judge's chambers, and the lawyers were coming in and talking to the judge, talking to him about their cases. And this one lawyer came. He was about 15 minutes late. He was all flushed and excited and out of breath when he finally made it to the chambers. Talked to us about his case. It turned out he had just come from seeing Ronald Reagan in a speech, and he was really excited about it. I can't remember if Ronald Reagan was president yet or if he was just running at that time, but this guy was really excited about having seen Ronald Reagan in this speech. And then so it came as a real surprise when the judge, without missing a beat, said to this lawyer who was so excited about seeing Ronald Reagan, "Well, we're all Democrats here." So that was an insight into the judge's mind and his perspective on the law, I think. Let's see. So you can change the slide there. After working for Judge Porter in Cincinnati, I got a job at this large law firm. It was called Mayer Brown and Platt at the time. Now it's just called Mayer Brown. There are probably over 1,000 lawyers or more in this law firm. It's an international law firm. And I was hired to be a litigation associate and got assigned to huge lawsuits that the firm was defending. And mostly I was miserable there, I have to say. It was a good firm and the lawyers were obviously very talented, but it really wasn't the kind of job I was looking for after law school. I was looking for more independence. And that's really what I thought being a lawyer was, someone who had their own journey in their career and also spent a lot of time in the courtroom. Those were two things that were never going to happen at Mayer Brown. I did work for a senior associate who did drive me crazy the entire time I was there. He loved assigning me work, especially on Friday afternoon. And one time he assigned me a project that was due on Monday. And basically that was the anniversary of our first wedding anniversary. So, you know, it was the kind of thing where you couldn't say no. They were paying us a lot of money and we had to do what we were told. It turned out later that this senior associate who was working so hard was also committing billing fraud and billing about twice the amount of time that he was actually working. The firm ended up pushing him out of the practice and he had to relinquish his law license. So I don't know. I just kind of feel bad for him, but not that bad. So you can change the slide there. So I was, as that story might indicate to you, I was pretty miserable at Mayer Brown and Platt. And I looked around for another job and really I only applied to one job, and that was at the Cook County Public Defender's Office. The office had just hired Randolph Stone from the Washington, D.C. Public Defender's Office. And he had been giving interviews about how he was going to professionalize the office and he was looking to improve the quality of legal defense that the Public Defender's Office was going to provide its clients. And I thought, well, that's really what I want to do next. So I joined the Public Defender's Office, and that basically meant a 95% pay cut, which was a bit of a shock to the system at the time. Somehow we survived. I think I had to ask for a break on rent from my landlord at the time. And so I went from working on LaSalle Street to working on 61st Street and Racine. This is a misdemeanor courtroom above a police station, a super isolated courtroom. We were living in Hyde Park at the time. I would drive down Grand Boulevard, is that the name of 55th Street? And head over to court, and then we'd park the car in a parking lot that was locked after we pulled in there, so it would be safe. So it was just the judge, me, and a couple of prosecutors, and we would try cases all day long, these little misdemeanors. And it was a lot of fun. I'm still friends with all of those people. We used to go out to lunch together. A lot of, I think the popular image of lawyers is that they're at each other's throats all the time. But I think the idea is that we fight hard in the courtroom, abide by the rules, and do what's right for our clients. But at the end of the day, we don't have to take it out on each other personally. It was such a shock to the system to go from a silk talking law firm, as they called these big firms back then, to 61st and Racine. The clients obviously were completely different, and I was really a fish out of water. I remember my first day having to go back into the lockup, and it was filled with guys who really needed my help. And I was inspired, simultaneously inspired and terrified, because I really didn't know what I was doing. And my supervisor at the time, who I loved a lot, said, "You'll figure it out. Everybody does." So that's how I learned the job. I have one fish out of water story that I remember from this time, was that I was representing a young man, and he came to court wearing an NFL jacket. It was a Cleveland Browns jacket. It was brown. And I'm from Cleveland. I grew up in Cleveland, and I'm a lifelong Cleveland Browns fan. So I said to this young man, I said, "This is great. You're wearing a Cleveland Browns jacket. I'm from Cleveland. Are you from Cleveland?" And he really literally looked at me like I was from Mars, because of course he wasn't wearing the jacket because it was from Cleveland or represented the Cleveland Browns football team. He was wearing the jacket because it was brown and it had the right color for his gang. Someone else had to explain that to me later. But it was a lesson that helped me along the way as I learned more and more about gang life in Chicago, which is pretty vibrant and pretty active. So after a year in various courtrooms on the South Side, I was transferred to 26 in California. And there I did everything that goes on at 26 in California, including bond court, drug cases, murders, robberies, everything. I loved it all. It's a hard job, you know, being a public defender. And while now I'm a public defender in federal court, it really doesn't compare to being in the trenches at 26 in California. It's super challenging. The clients are suspicious of you. Your neighbors really don't like what you do. And your parents think you're squandering a very high-priced education. But I loved it. I loved it every day. And I still miss those days. At the time I was living with, you know, Lori and I were married, and it was just the two of us. We didn't have kids. And I would bring the work home from time to time and look at reports. And I can remember one time I was going through some pictures of a crime scene. It was a murder scene. And the pictures are gory. I mean, these are the pictures that are taken by the police officers. As soon as they get to the scene, there's blood everywhere. The bodies are sitting there, you know. And I think the phone rang, or I got called away, and I completely forgot that the pictures were there. Back from wherever she was coming from and saw the pictures sprout out all over the table, kind of freaked out. And I realized I'm taking these pictures for granted, what's in here. I'm seeing these every day. That's kind of weird. And I started keeping them away from Lori, along with a lot of the other details of what I had to deal with. Because, you know, I really didn't want to traumatize her any more than I was already traumatized by the whole thing. But Lori would remark that whenever public defenders got together, they really had a demented sense of humor. Because, you know, you're in this world, this crazy world, and you forget what it's like to be out in normal society in a lot of ways. So, but those days are long behind me. You can show another slide. So I went into practice with a friend of mine named Robert Cohn, and his specialty was employment litigation. And I was doing criminal defense, and we had this brainstorm that he would do civil cases that we could invest in and might pay off down the road, and I would bring in cash up front representing defendants in criminal cases. And I was ambitious. At the public defender's office, there was the murder task force. Yes, that's an actual name of one of the departments in the public defender's office. And I wanted to be on that murder task force, and I might have stayed in the PD's office longer if I had gotten there. But unfortunately, for me, all the promotions were governed by seniority. And it was a long way away. I was probably 5 years away from getting on the murder task force at the time that I left the office. And at that time, 5 years seemed like an eternity. Although looking back, it was a blink of an eye. But I was ambitious, and I wanted to get into a lot of different kinds of cases. So we started this practice, and one of the things I did is I signed up for every possible appointment panel that I could get on. So I was receiving appointments from the Court of Appeals in federal court, the Court of Appeals in state court. I was getting appointments from juvenile court. I was representing people in the juvenile court has two sides to it. There's the delinquency side, and then there's the abuse and neglect side. So I was getting appointments representing individual defendants on the delinquency side. And I was also getting appointments to represent parents who have had their children removed from them on the abuse and neglect side. And that was hard work. But the panel that really paid the bills and really interested me the most was the Criminal Justice Act panel in federal court, which gave appointed cases to individual attorneys to represent federal court. Because the federal defender office in the Northern District of Illinois in Chicago didn't have enough attorneys in it to represent all of the defendants who were arrested in the Northern District of Illinois. So they had this federal defender panel, and they have these panels in most districts across the country. And over the couple of decades that I was on this panel, I financed a lot of my law practice representing people in federal court. So what kind of cases are in federal court? Well, I handled multiple death penalty cases in federal court. I also did those in state court. I was qualified to be lead counsel by the Illinois Supreme Court in death penalty cases. I represented white collar criminals, as I've already said, doctors, lawyers, accountants, bankers, but also gangbangers and tax cheats and just any kind of crime that you can imagine. Some of these cases were actually scary in some ways because like the bigger gang cases were the result of possibly up to years of investigation, wiretapping, things like that. The wiretaps would all the recordings from the wiretaps would be transcribed and provided to us in discovery so that we could prepare for trial. And many nights I would stay up late reading those transcripts, and the transcripts they were kind of like jarring, because you'd be reading about people just planning murders and drug deals and all kinds of crazy violent things. And while I didn't have any qualms representing the people who were charged with these crimes, actually reading their words as they planned them was a little bit shocking. The federal government, over the time that I was practicing, got better and better at getting these wiretaps where they needed to be to record these conversations. So the transcripts got more and more complete. And I lost a lot of sleep reading those transcripts. As far as the death penalty cases go, the Illinois had an active death penalty until I can't remember the exact year, but Governor Ryan repealed the death penalty. But up until that point, they needed qualified death penalty lawyers to represent people charged with death penalty eligible crimes. And of course, these are the most brutal murders that you can imagine, including murders involving multiple deaths, mass murders, things like that. So representing someone in a death penalty case is a completely different animal than representing someone in just a regular criminal case, because your goal is not necessarily to win the case outright, but to save the person's life. And, there's a lot of sort of legal technology, things that you can study and learn about, the selection of a jury, how to try the case, what motions to appeal to during the trial to actually convince the jury not to impose the death penalty on your client. It can be an uphill battle because a United States Supreme Court case disqualifies anyone who is morally opposed to the death penalty from serving on a death penalty jury. So when you select a death penalty jury, everybody gets asked, can you give the death penalty? And if you say no, you're kicked off the jury. So you automatically get a jury that's naturally predisposed to impose the death penalty ultimately. So you have to find those people who are reluctant to give the death penalty and appeal to them. Because the one thing about the death penalty is that in order to impose the death penalty, the jury has to be unanimous. And if you can find one person on a jury that's going to say no death, then you can win the case. Let's see. You can give us a new slide, Charles. That's the Monadnock building where I practiced. My office was in that building on the 16th floor. And the next slide. And that's where I work now in the Northern District of Indiana Federal Community Defenders. And you can give us the next slide. And that's the courthouse where I go to work. It's one of the older courthouses. It used to be a courthouse and post office, as most of those buildings were. There's still a couple beautiful courtrooms in there. There's been some talk about tearing it down and building a new one, a brand new one, but I don't think I'm gonna see that day. You can show us another slide. So for those of you who don't know, this building is downtown and it's the Metropolitan Correctional Center. And this building was designed by locally renowned architect Harry Weiss. It's a jail. And I spent part of every week inside this jail. And these little slits here, these are actually cells. When you're visiting a client, you're in one of the non-used cells, so you can look out these tiny little windows. Up here is where they get fresh air. So you can just make out the orange suits of a couple of, maybe 3 guys who are up there on the top deck getting some fresh air and maybe even playing some basketball. Not that long ago, a few years ago, a guy was actually able to carve out one of these tiny little slits and do that old thing where he tied a bunch of sheets together and escaped. It was amazing because every night there's a guard who walks around the perimeter down here. It was just pure luck. The 2 guys were able to squeeze through this. I mean, I've never been skinny enough to be able to squeeze through one of these things. So I have no idea how they did it. And get away. But of course, they had nowhere to go. They spent all their time planning how to get out and they didn't figure out where they should go. So the one guy went to his sister's house, knocked on her door, and she said, "Get away from here. I don't want to have anything to do with you." And I forget, they just picked up the other guy walking around downtown. So they made it that far, which is a miracle, but they got arrested pretty quickly. Now, over here is a parking deck. And there's a bit of a story around this parking deck. I was representing a guy. Can we go back to the last one? I was representing a guy who was charged. He was part of a huge drug conspiracy that involved violence, murder, torture, all kinds of things. And everybody in that conspiracy got in trouble. What was that? It was they were having their girlfriends drive up to that parking deck and give them a striptease every night. And so it wasn't the MCC that complained. Finally, there were some neighbors over here and some of the condos over here that were watching this activity night after night. And finally, the police broke it up, which was sad for the clients, I guess. Okay, now we can go to the next one. number 11. This is the Cook County Jail. And this is Division 9, the maximum security dormitory, the most serious one. I've been behind these barbed wire fences. I can't even tell you how many times, hundreds and hundreds. And this jail in here is the place where they keep the most difficult inmates who have caused trouble for the guards. I heard stories from the guards all the time of getting just stuff thrown at them, feces, urine, whatever. It was not a very pleasant place to be, either as a guard or as an inmate. There were a lot of fights, crazy. As someone in custody, to give an inside tip, you always want to be in the lower secure facility where the nicer guys are. So that might be something to keep track of if you need that advice. And what's the next one? This is the inside of one of the jail decks, and Lori found this picture for me. I just thought it was interesting here. The guards are breaking up a fight. They're all coming out of usually the guards are in here, and this is a locked door. And then the attorney visiting room is on the other side. You can just make it out. There's another door over here. And but here the guards are coming running in and they're breaking up a fight. Meanwhile, these guys are just sort of staying out of it, which is a wise thing to do. So jail is a terrible thing. I mean, people think that it's not painful enough for people who have committed crimes against society, but I'm here to tell you, it's horrible. You never want to be inside one of these things. Okay, you can give us the next slide there. This is what we call the bullpen outside of bond court. You can see this, there's a lot going on in this picture. These are sheriff's deputies who have booked all these guys and are keeping track of them so that when they get called into the courtroom, they know who to call. All these guys have magic marker numbers on their hands. And so they're being kept track of not by their names, but by their numbers. So, and you can see just being in this bullpen, it's pretty dehumanizing. And, you know, the lawyers come here and we talk to them and they're desperate for information, and they don't always like what you have to tell them, unfortunately. They just want to get out in the worst way, or at least move on to the next part of the system. This line here, this is a line on that is loosely enforced, I suppose, depending on who's in charge over there. The inmates are supposed to be on one side and the civilians are supposed to be on the other side. So, you know, you're supposed to keep your distance from them. But as a defense lawyer, you really don't want to keep a distance from your client. I mean, from the very beginning, you want to start building that rapport and relationship, and you want to show the world that this is not a dangerous person, that you're there to advocate for them. And it's the correct thing to do to let them go, ultimately. Bond court is also a crazy situation in 26 in California. I mean, these guys only get about 1.5 minutes in front of the judge before the judge has to make a decision on whether to keep them or give them bond. Things are changing in the bond arena right now. There's a movement to get rid of cash bond, and all the judges in bond court, they're younger judges. I know a bunch of them, and they are working on letting more people out. I suppose you're in Chicago and you've been reading about that. The police are not happy about that. Some communities are not happy about that. But when you're confronted with this situation, you realize that it doesn't make sense to keep all these guys in there. Okay, we can go to the next slide. Okay, so I'm going to talk a little bit about the practice of law, and then we'll get to some questions. The practice of criminal law starts with the United States Constitution, we the people. Next slide. But really, the tools of the trade are right here in the Bill of Rights. And most importantly, they're the 4th, 5th, and 6th Amendments to the Bill of Rights. The Fourth Amendment is search and seizure. The Fifth Amendment is the right to not be coerced to testify against yourself or give a confession. And the Sixth Amendment is the right to a fair and speedy trial. And the Sixth Amendment, although it's not specifically enumerated there in the Sixth Amendment itself, but it has been interpreted to include not only a speedy trial, a right to a jury, a right to confront witnesses, a right to call witnesses, and a right to have an attorney present. As far as this right to have witnesses goes, I always tell my clients that if we go to trial, we have a right to subpoena witnesses in their defense, and if they don't show up, we can have them held in contempt of court and eventually arrested. And actually, I've done that, had witnesses arrested so that they would come to court and testify for my client. It's not really what you want to do because obviously they're not so happy to be there. But the Constitution gives us all these tools to give our client a fair trial. Next slide. The main case, this was a 1963 case called Gideon versus Wainwright. And this guy, Clarence Gideon, on his own, representing himself, petitioned to the United States Supreme Court and changed the law and said that every defendant who is facing incarceration is entitled to a lawyer, whether their own lawyer or an appointed lawyer. And that was really the beginning of public defender offices across the country. And then I have a story about that. I remember I was representing a woman who I had initially met in juvenile court when they removed her children, and we fought to have them returned to her. This is a case I think about all the time. Years later, maybe it was 10 years later, one of the children actually died. And my client was charged along with her husband with the daughter's murder. And her family called me that night and asked me if I would go to the police station. It's when you're called to the police station, there's really only one thing to do, and that's to tell your client not to talk to the police and to tell the police that your client's not talking to them. At that moment, the police are only interested in gathering evidence, and they have a theory. Their theory is that your client is the guilty party. So it never pays for your client to talk to the police. And the only competent advice at that moment is to tell your client to not talk. So I ran down to the police station. It was at 111th and Ellis. It's really far away, all the way down the Dan Ryan. It was in the middle of the night. And I was walking into the doorway, walking towards the police station from the parking lot. And I looked down and in a basement room, I could see my client sitting there at a table. And so I went into the police station and I told the detective there or the sergeant at the desk, I said, I need to talk to my client. He said, who's your client? I said, I gave him the name. He said, she's not here. I said, what do you mean she's not here? I just saw her in the window. I walked right by her. She's in that window. Come out with me. I'll show you where she is. He said, she's not here. I went back outside. There she was in the window again. So I go back inside and I said, she's here. I need to talk to her. I demand to talk to her. He said, she's not here. I don't know how I can let you talk to her when she's not here. And then when I went back outside again, she was gone. So, you get the Sixth Amendment right to counsel, but that doesn't necessarily mean your counsel is going to be allowed to talk to you. In some ways, the Chicago police have improved in their consideration of the client's rights. I'm not sure this exact same scenario would play out today, giving them the benefit of the doubt, I guess. But that's what happened then. Okay, we can talk about the Fifth Amendment. Okay, the Fifth Amendment. The Fifth Amendment is the right to silence. And what develops out of the Fifth Amendment is the Miranda Warnings. So the United States, you might have heard about the Miranda Warnings or seen them given on TV. Well, they are actually given, usually from a pre-printed card. And now that all police interrogations are videotaped, you can actually see before they begin, the police officer taking out his pre-printed card and reading the Miranda warnings. And that basically tells the person that they have a right to silence and a right to an attorney. But that doesn't mean they're going to take advantage of that right. I can't even begin to tell you how many of my clients actually talk to the police. And they just think they're going to talk their way out of whatever it is, and they're only talking their way into it. I remember when I was a public defender, they had a seminar for us at the jail, and we were in a room with about 50 defendants, and the lawyer who was teaching this particular program said, I just want to ask everybody, who in this room actually gave a statement at the police department, at the police station? Everyone raised their hands. I couldn't believe it. Okay. You have a right to silence. That's a very important right, probably the most important right that a suspect has when they're at the station. Okay, next slide. The right of, this is the Fourth Amendment. This is the search and seizure amendment. You have a right to not have the government search you unless they have probable cause or they've gone to a judge and gotten a search warrant. And this applies to searches of your person, searches of your car, searches of your home. And the Supreme Court, it's a very dense area of the law with many, many cases, and there are many different rules and standards of review and things that the police have to do with regard to searching all these areas that may affect you. So car searches, there's aerial surveillance, there's now electronic surveillance. They can pull your location information from your cell phone. These are all areas that have been litigated in the courts to determine whether you have a right to have a warrant issued before such a search takes place. It's a constantly changing of the area of the law, and it's probably the area of the law that I use the most in my practice. I just filed a Fourth Amendment motion last week for a guy who was driving home with his baby in the car. The police officer heard a noise, a scraping sound. He followed my client's car. My client says he was doing 40 in a 40, but the officer said he was doing 44 in a 40. He pulls the client over, and client cooperates, gives him his driver's license, and the officer orders him out of the car. And when he gets out of the car, this is in Indiana, remember, he's wearing a sidearm. And he had a prior felony. He wasn't allowed to have that gun. It's a federal offense. And, you know, the video captures him carrying that gun. If we go to trial, we're going to lose for sure. It's like the most evidence ever. But he has a Fourth Amendment right to not to have that search take place, as far as I'm concerned, because I don't think that the officer had a right under Supreme Court case law to order him out of the car under those circumstances. But finally, it'll be up to the judge to decide. So we'll litigate that and we'll see what happens. Some people think that filing these motions is a technicality. You're winning on a technicality and you're helping a guilty person get off. But you're also moving forward the sanctity of the Constitution, which protects all of us, protects us from intrusion by the government, and maintains that we have rights as citizens of the United States. So that's the job we do. Okay, next slide. In federal court, the sentencings are all determined in some way or another by the federal sentencing guidelines. Most people aren't aware that these guidelines even exist. It's a very dense book. Here's my copy of it. It's this thick. It's filled with sections. It's kind of written like the Talmud with, there's a black letter rule, and then there's commentary, and then there's judicial opinions. So there are many layers of discussion about each rule. It's a point system. There are points added and there are points taken away. And at the end of the day, and you can change the slide. At the end of the day, after you've calculated the points, you go to this table. And along the top level is the point system that represents your client's criminal history. If they've had a couple felonies, they're going to be in criminal history category 3, 4, or 5. If they're really, if they have a really bad record, they're going to be in criminal history category 6. And then along this axis is the offense level, you know, depending on the crime. So just to take for an example here, if you're charged with the gun case that my client is charged with, he would probably, it's the guideline is guideline 2K 2.1. He would start at level 14. If the gun was loaded with more than 15 rounds, he would get 2 extra points. If he pleads guilty, he would they would take up to 3 points off his sentence. And he's probably looking at a sentence somewhere, because he's got a somewhat of a criminal record, around 18 to 24 or 24 to 30 months. And that's, you know, when I sit down with him, that's how I talk to him. That's the advice I would give him. This is what you're looking at. What do you want to do? Do you want to fight the case or go to trial? He said, I want to win the case. So that's why we're filing the motion to suppress. Hopefully we'll win the case. The guidelines are so complicated. The Seventh Circuit, my boss just circulated an opinion, a Seventh Circuit of opinion that found an attorney incompetent, ineffective, because this attorney didn't raise an objection to the guidelines that wasn't even recognized in the law at the time he was representing his client. It was just something that was kind of brewing in the law. It had been argued about, but there hadn't been any cases in the Seventh Circuit that actually recognized that objection. They found the lawyer was ineffective, and they sent the client's case back for resentencing. Okay, you can go to the last slide. So I love this slide. This is Bart trying to get off on a technicality, and Mrs. Krabappel is punishing him for it. The Fifth Amendment, as I said before, is not a technicality. Winning a criminal case, even though I guess the general view in the community is that most of our clients are guilty, but the system is adversarial. It requires both sides to fight hard, but also fair and square. And that's how just results are obtained. When the clients believe that they've had a fair fight, they're okay with losing, and they're okay with being punished. They want to know someone's gone in there and fought for them, advocated for them, and they've received justice. It makes a big difference. Without that sense, there wouldn't be a general feeling that the court is a place where justice and fairness exists, and people would revolt, basically. So getting someone off, even a guilty person off, using your skills and talents and the law, it's never getting someone off on a technicality. It's just doing your job. And that's the life of a criminal defense attorney. I can answer some of the questions now that I've seen popped up. Carol, I did know Harold Winston. He was a great guy. I didn't see him very often after I left the office, but he was the kind of guy who would he knew the answer to every question. So if you had a legal question, you ran into Harold, you could, even after I was in private practice, I would say, hey, Harold, you know, what about this? I'm going into court right now. I have this motion. And he would know a case. So, you know, he would just help you with it. How do you, so you know him too, huh?
Herb knows him.
Oh, okay.
Through his synagogue.
I just thought everybody loved Harold.
Don't play, you didn't want to play chess with him either.
Oh yeah, I heard about that. He was a master.
Thank you.
Scott, do you want me to read off questions, or do you?
Yeah, you could do that. Yeah.
Okay. So we have a question from Alan Paris. What qualifies a defendant for representation by a public defender?
It's just income mostly. And it's a loose standard. The judge takes a look at the client's income, what kind of case it is, and will decide, you know, there's no appeal from that decision by the judge. So the judge has a lot of discretion on whether to appoint you or not. Like I said, I've represented doctors and lawyers, whatever, you know, some of these cases were enormous cases. And after the judge looked at the person's income and what they were charged with, they appointed me. I've been hired by those people too. They do have money, and I have been hired by them, but I've actually also been appointed to represent some professionals along the way.
So speaking of clients, the ones who are not the white collar criminals, there's a question from Jay. Have you ever had a client of whom you were physically afraid? And if yes, how did you handle that?
You know, I have to say that has happened, rarely, but it has happened. And at the MCC, the building I showed you before, when I first started going over there, they would say, okay, go through that gate, go through the next gate, go up that door, we'll fire the door for you, and then you'd be in all on your own. And the client would come out and you'd have a meeting with them. Over time, I think the lawyers, there's always a lawyer that's going to take advantage of that. People would sneak cigarettes in, cell phones. It was just unbelievable. So eventually they locked us into these tiny rooms with our clients. And yeah, most of the clients, 99% of them are happy to have you there. But occasionally there's a guy who just gives off a scary vibe, let me tell you. And I would always go in there. I mean, you have to do your job. I would tell the guard, you know, I'm a little nervous about this guy. So would you just don't forget about me in there? If you hear me pounding, it's because I probably need to get out. But nothing ever happened. I was never touched by a client. You know, certainly I did receive, you know, some clients get mad at you and they do say scary things to you. But after thinking about it a couple days, hopefully it goes away.
Right. It brings to mind the scene from Young Frankenstein, right? where he goes into the room with the monster and he says, don't let me out. Don't open the door, no matter what.
Yeah.
The opposite.
Exactly.
Sarah Stern asks, how has COVID changed how you do your job?
Well, I do my job. How I do my job is this. I'm doing most of the work through Zoom. I'm doing court appearances and jail visits through Zoom. At first, I thought it would be challenging because you want to have that contact with your client. But I actually have been able to visit them more often because I don't have to travel or get locked in the jail. I mean, if you have to go to the jail, they open the door and then lock it behind you and you're stuck. And after your meeting, you have to wait for them to come and get you. And if they're busy, if there are other things going on, sometimes you're there beyond, you know, when you wanted to be there. And it just takes a lot of time. On Zoom, they bring the guy to a room, they set him up with a computer, or it's FaceTime actually, and you can have your meeting. It's actually much more efficient. I'm looking forward to getting back to the jail and in a perverse way and actually seeing guys in person. But this has been.
It'd be funny if that changed.
We're not muted.
The question I had was related to that picture of everybody in the waiting cell.
Right. So those guys, they probably are all appearing now on Zoom. I know that Cook County has gone completely video teleconference. All the judges are remote. But the other side to your question is what's happening to them? I mean, Cook County was one of the national, a site of one of the most serious outbreaks of COVID. And a lot of the guys in there are elderly, they're not healthy, they haven't had good health care, and they're drug addicts or alcoholics. So it was scary. And I actually was, I represented someone in a federal penitentiary because the Congress passed the CARES Act, which made it possible for these guys to move for compassionate release. And I represented a bunch of guys. I lost a lot of them. But I did manage to get one guy out on compassionate release, so I'm pretty proud about that because of the risk of COVID in the penitentiary where he was living.
Well, along the lines of incarceration, somebody asks, how often is bail denied and why is that the case?
That's a good question. I mean, in state court, it seems like there's more flexibility regarding bail, but I'm not really practicing in state court anymore. In federal court, in the Northern District of Indiana, where I practice, it's a pretty conservative jurisdiction. And even though the judge who does the detention hearings, the magistrate, he seems like a pretty liberal guy for Indiana standards. He basically keeps everyone in custody. I would say I've lost 95% of all the detention hearings I've done since I started there a couple years ago. And it's a source of frustration for me. And, I'm constantly thinking about what we could do differently to change those numbers and talking to my boss about it. But we haven't done anything yet. People still keep getting locked up. They're locked up. They're getting charged with gun cases. And in Indiana, it's a federal crime to have a gun if you have a prior felony conviction. But in Indiana is a wide open gun state. People are walking around with guns. It's unbelievable. And so to keep these, they don't see guns as the kind of the dangerous thing that I always thought of guns living in Oak Park, where guns were banned, and Chicago. But they see guns as just an everyday thing. People just have them in their cars and leave them out on their coffee tables. It's just, so to keep a guy in custody because he has a gun doesn't make sense. It's out of sync with everything that's going on in that district. So I'm trying to make that argument, but it doesn't seem to be working.
We have a question about Miranda. Alan Paris asks, when the Miranda ruling became effective, it had repercussions beyond the U.S. He says in Canada, because of the ubiquity of American cop shows, Canadian criminals thought they deserved Miranda warnings, but they, I guess, did not have that same protection.
I don't know. I mean, I've seen.
Yeah, no, it wasn't a question. It was a comment that it kind of had repercussions on the Canadian justice system because Canadian criminals would get arrested and if I remember correctly, they could actually be held for 48 hours before being charged. But they would say, I didn't get a Miranda warning, and the judge would say, we don't have a Miranda warning.
Yeah. Well, even in the United States, I mean, the whole time, most of the time that I was practicing law in Cook County, the clients would say, I never got my Miranda warnings. Then you get the police report and it would say, the first thing we did is we gave them the Miranda warnings. And this is before anything was videotaped. And, you have to believe that some of these clients were telling the truth. They never got the Miranda warnings, but the cops, it's so easy to fabricate. Now that things are videotaped, the body recorders and the dash cams, and they actually videotaped the interrogations, they can't get away with that. Everybody gets their Miranda warnings. But it's hard. The Miranda warning itself is rarely going to win a case for you. I mean, there has to be, you're going to win a case if there's been some kind of coercion, some obvious denial of rights, some physical coercion, or, somebody's been left in a cell for 3 days, which happens. No food, no bathroom breaks. I have watched videos where my client had to pee in the interior. He was there for so long, he just got up and peed against the wall on video. So, the police have many tactics for putting pressure on the clients.
So speaking of that, before I ask this last question, I was just curious. You mentioned that you think that the Chicago Police Department has changed a little bit and that some of the perhaps more egregious behavior of the past is not as prevalent. And I'm thinking back to, all of the litigation and the lawsuits because of the John Burge era. And is there a lot more external oversight that really is changing the things, or is it just the cost of all of these cases that's changing their behavior?
I think it's a combination of all of the above. I mean, the lawsuits are really expensive. My partner and I brought a bunch of lawsuits against various police departments and jails and sheriff's offices, and it can get really expensive for them. But also you have a new state's attorney, relatively new state's attorney, who's trying to implement a new approach towards prosecution and law enforcement. And I think the officers are better trained. So I do think things are changing. Over the course of my practice in Chicago, I did see a definite improvement, but I don't think it's for any one reason, but just all those different factors.
And I think we have one last question. And actually, this will be a good answer because I'm not sure what this is about. It says, are you fond of the fruit of the poisonous tree doctrine?
Yes, I am. I put it, in fact, I put it at the end of every motion to suppress. So is that a question from Len or Larry?
It just says iPhone.
Larry.
Can you explain what it is? And then,
So because I've been talking so long, I'm drawing a blank on the case, but the Supreme Court said that if there was a Fourth Amendment violation, not only must the court suppress exactly what was seized as a result of the Fourth Amendment violation, but also anything else that flows from that seizure or arrest, including statements or evidence may be later found as a result of the statement. So you can you can follow the thread of whatever the whole poisonous tree, as it says, and get everything suppressed. And then eventually there was a case where the Supreme Court said, well, not everything has to be suppressed. The court can do a hearing and decide if what you're asking to be suppressed is really related to the original violation. So, yeah, an attenuation hearing, it's called.
well, I think we might say we've had a wonderful talk with you and call it an afternoon. This has been really terrific having you let us into your life and the things that you do. And I speak for everyone when I say this was really thrilling and very interesting and exciting to hear you talk about everything.
Great. Thank you so much. Honestly, I'm humbled and honored that you asked me. It was just
Great.
enjoyable. Thanks for coming, everyone.
Good to see you. Have a good Pesach.
You
Yeah.
too.
Thank you.
Thank you. Have a good day.
Thank you.
Have a good Passover.
Bye.
Thanks, Scott.
Happy Passover, everyone. Thanks, Frank.
Bye-bye.
Thanks, Scott.
Thanks,
Happy
Scott.
Passover. Thank you.
Thank you, Scott.
Thank you. Bye.
Bye-bye.
Wow, a lot of people.
Yeah, we had about 34 at the height.
Wow.
Yes, Micah?
Awesome. Thank you. I'm going to leave.
Thank you, Scott.
All righty. Thank you very
You're
much.
welcome.
Thank you, Scott. It was great.
Really
Thanks for
good.
coming.
And thank you for Lori for sitting through that.
She's heard it all before.
I know, that's what I was going to say. I could see on her face. She's like, I know this story. I know this story.
How much did you have to pay her to not say anything to contradict you?
I think I have to make dinner tonight.
There you go. There you go. All right. Wonderful. Have a wonderful afternoon. Enjoy the rest of the weekend. And let's talk soon.
Yes, we'll see you soon in person, hopefully.
Yes. Wonderful. All right. Thank you so much.